Chapter 13. Arbitration. Outside sources are underlined in blue text. Forms available in our Forms package are underlined in red text. Links to each are below this video. Better justice at a fraction of the cost. Arbitration is one of the two most popular alternative dispute resolution (ADR) methods. Mediation is the other. This chapter deals with the arbitration process, which is initiated by a written arbitration agreement. Arbitration is often preceded by mediation, which has an 85% success rate. In the remaining 15%, most litigants proceed to arbitration instead of the court system. Definitions. Litigation means taking a dispute to the public court system. Both sides present their case before a judge or jury, who will then render a decision. Anyone in the United States can file a lawsuit in the court system. Arbitration is a private process where the parties agree that an arbitrator will render a binding decision. A person cannot submit a matter to arbitration without the written consent of the opposing party. Once parties agree to arbitration, they have given up their right to have their dispute decided before the public court system or to file an appeal. The difference between mediation and arbitration. The biggest differences between the two processes are: mediation is a cooperative process, a settlement prelude to arbitration or one's day in court. It does not replace existing legal rights. Arbitration is an adversarial process that replaces one's day in court. Arbitration is a confrontational process that entirely replaces the prolonged, arduous court system which we refer to as the House of Horrors. While arbitration steps resemble those found in the court system, the process is considerably streamlined, thereby terminating the dispute quickly and more efficiently compared to the court system and at a comparatively nominal expense. Arbitration yields a decision by the arbitrator against one or more parties. By agreeing to arbitration, you and your opponent give up the right to access the court system, to have a trial by jury, and to appeal the judgment. In return, you receive an immediate stage to present your case and obtain a verdict. The evolution of arbitration. Alternative dispute resolution, ADR, alternative meaning outside of the court system, was created nearly a century ago to avoid the costs, delays, and risks of a litigation system unresponsive to the needs of the industrial age. The American Arbitration Association, AAA, was then formed to advance the use of arbitration nationwide. About 40 years ago, mediation joined the ADR League as an even more proactive answer to legal dilemma. ADR is now a fierce competitor of the courts and has become a highly respected industry standard. The reasons for arbitration. Your mantra: arbitrate instead of litigate. The two most important reasons to arbitrate instead of litigate are saving time and money, two of humanity's most valuable assets. Instead of waiting 2 to 5 years for your case to be decided in the upper civil courts, aka the House of Horrors, most arbitration claims are heard within a few months. Instead of spending years paying attorneys to use their litigation arsenals of expensive and endless fact-finding tools, Judgment Day arrives soon, often without the use of these fishing expeditions. A soon hearing date. One of the major advantages of arbitration is that you are assured of a hearing date in the next few weeks or months unless you have a complex case. Sometimes it can take place in as soon as a week. In the upper civil court system, most often you receive several trial settings before you go to trial 2 to 5 years after your case began. What? 2 to 5 years, are you kidding? Nope. It's really true. With arbitration, you are set for a definite date, and on that date the proceedings begin and possibly also end. In our modern-day culture of go, 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 disputing parties are no longer willing to devote years to resolving their disputes. They have better things to do and certainly better ways to spend their nest eggs. They are choosing the House of Resolution instead of the House of Horrors. Ask yourself, do you want to have your dispute decided in a streamlined process like arbitration or in a house of horrors? The decision is obvious. Little or no discovery. The court system is built for fishing expeditions. Without them, the parties would file suit and patiently wait years for their day in court to finally arrive. This would probably be a better way, but during that time they also forget the all-important details of the dispute. This is what the litigation frenzy is all about, fishing for information by various legal techniques. During this wait time, the litigation arsenal, depositions, interrogatories, document productions, various motions, is active, ratcheting up emotion, adversity, time, and expense. These fishing expeditions are meant to clobber and to trip up your opponent. Get them on the stand at trial and pull out their deposition or interrogatory answers and point out the difference in answers. It's an expensive, confrontational, needless experience. In arbitration, discovery is significantly limited to avoid this futile fury. This subject is detailed later in this chapter. No appeals. Arbitration results in a judgment, as is the case with the court system. Yet, in arbitration, the battle is over. Done, kaput, no appeals. In the court system, after lambasting one another for years and finally receiving a judgment, the parties get to appeal the whole fiasco, dragging it out yet another year or two. Something like the Bible story of Job, a whole new chance to get it their way. Varied platforms. More contemporary technology-based platforms have recently evolved, giving ADR users more options, especially in the arbitration arena. We now have vastly improved online arbitration portals upon which to stage our proceedings, and a trend toward mid to low value cases enjoying even more streamlined portals. As previously described in the ADR chapter, most providers offer a less complex, expedited procedure for disputes with minimum values, recognizing that these types of cases should enjoy a more simplified, expedited process, sometimes by submission of documents only. Smart Cookie Tip. You can customize your arbitration to enjoy one of the more abbreviated platforms regardless of whether your case falls within a provider's streamline category. Just get the agreement of your disputing parties. The litigation arsenal has no place in these streamlined platforms where discovery is highly discouraged and significantly limited. The document-only platform allows disputing parties to seriously consider representing themselves, since they will not be required to model the oral skills of a trial lawyer. Upper civil courts equals house of horrors. How do you get to arbitration? You always come through the arbitration portal with an agreement signed by you and your disputing parties. No one can be required to arbitrate unless they agree to do so by choosing arbitration over the house of horrors. You must have a written agreement to arbitrate. Because arbitration is not an automatic legal right, you cannot require your opponent to use it. Your adversary must agree to it in writing, which can be signed by the parties before the dispute arises or amidst the dispute. Why must the agreement be in writing? Because the parties are giving up their legal right to have their dispute decided by the court system. Once they sign the arbitration agreement, as long as it is binding arbitration, as opposed to advisory arbitration, the parties have no right to use the house of horrors to decide their dispute. Phew, what a relief! Smart Cookie Tip. Because these important legal rights are given up in arbitration agreements, some states and some industries have created stringent rules for these agreements to be enforceable, where a certain bold type, specific wording, and separate initialing must be used. For this reason, our forms must be customized to conform to those specific requirements to assure your goal, to enter the arbitration door and close the gates forever to the house of horrors. If you don't have an existing arbitration agreement, an agreement signed now by all parties to the dispute will do the trick to detour you out of the house of horrors. It doesn't matter when the agreement is signed. It just matters that you have one. Otherwise, you must take your dispute to the court system. There are some exceptions, but this is generally the rule. Your best opportunities to propose arbitration. Whether you are a defendant or a plaintiff, cost-efficient and expeditious arbitration is a wise choice. In either role, you can propose arbitration to your opponent at any time. In former chapters we covered this topic, yet we are repeating here to emphasize its importance. If you allow it to penetrate your mind, you will very likely extricate yourself from the house of horrors. Here are some of the best occasions. Just before the court case is filed. Just after the court case is filed. No settlement after demand letter. Just before the court case is filed. At the case management conference. When depositions are set, before they are taken. Before or after a deposition. Before, after interrogatories, requests for document production or requests for admissions are initiated. Before or after a motion is heard. Before trial. When a trial date is continued. Any case change. No settlement after demand letter. If your initial demand letter recommended in the settlement chapter fails to produce settlement, follow it up with an ADR proposal, including arbitration. Before court case is filed. Have an about-face with your adversary. Make the attorneys and the courts the enemy instead of your opponent. Your opposing parties are also interested in curbing their losses and should welcome a proposal with a mutual mission statement, saving attorney fees, time, and stress. Just after the case is filed. Potential defendants unwilling to arbitrate before a court action is filed in the House of Horrors oftentimes get far more cooperative once they are served with legal papers. Service of legal process has a way of creating a whole new attitude. Once the legal process takes hold, it's a real attention-getter. The person served suddenly becomes a good listener. Now is the time to propose arbitration once again. The chances are far more likely at this stage that your defendant will be inclined to agree. At the case management conference. Recognizing the value of ADR as a proven way of resolving legal disputes, nationwide the backlogged courts now refer their own cases out to alternative dispute resolution. This creates a court-ordered about-face for the parties which works incredibly well. At this hearing, often called a case management conference, 3 to 6 months after your case is filed, the parties must select a form of alternative dispute resolution before they move forward with their court battle. The parties agree to either mediate their dispute, submit it to arbitration, or both. The court cannot force you to arbitrate, but they can force you to mediate, and they do. This is the perfect opportunity to detour to arbitration. Unless self-represented, attorneys have been hired, the lawsuit has been filed and responded to, issues have been framed, and the litigation grind has begun. You and your opponent had a taste of the House of Horrors and attorney fees. Even if the parties were against alternative dispute resolution before, the atmosphere is ideal for a change of heart. The courts offer you a choice of advisory arbitration, where the arbitrator's judgment can be accepted or rejected. If rejected, you bounce back to the House of Horrors, or binding arbitration, the arbitration we speak of in this course. At or before this hearing, do your utmost to get your opponent to agree to binding arbitration, which will forever remove you from the House of Horrors and its artillery. A deposition has just been set. Early in your dispute, when attorneys send out notices of depositions, costs are about to skyrocket. The pre-deposition phase is an ideal time to propose arbitration. Your motivating factor, saving money. You'll each spend about $5,000 for one deposition. This can get anyone's attention. Not only can your arbitration proposal head off the delays and costs of trial, it can limit the number of depositions or exclude them entirely. You create your arbitration proposal, so it's up to you. A deposition was just taken. You and your adversary are sick of answering questions. Who likes being sworn in to tell the truth under the penalty of perjury as your testimony is taken down by the court reporter to be dissected later and used against you? The post-deposition climate is ideal for proposing arbitration. after discovery is initiated by either side. Interrogatories, requests for document production or requests for admissions will each involve another $3,000 of attorney time for each side and quite a lot of the parties' time. Put a hold on these expensive fishing expeditions while you detour into arbitration. Before or after a motion is heard. Various motions are made while a case travels through the litigation frenzy. A motion costs each party another $3,000 or so. Before and after each is another ideal time to propose arbitration. At any case change. Whenever the picture of your case changes, another unique opportunity to propose arbitration is at hand. At each of these junctures, make an ADR proposal or at least make a settlement offer. Your opponent may not have been receptive earlier in your dispute, but now she may jump at the chance to leave the house of horrors behind. Before trial. Trial preparation is incredibly time-consuming, stressful, and expensive. The litigation arsenal is in full swing. Depositions that haven't been taken need to be set. Sometimes you will need to hire experts. At least a few months before your first trial date, yes, you may have many trial settings, before you spend the rest of your nest egg, propose arbitration. At trial continuances. You can't assume you will go to trial on your first or second or third trial setting. Each continuance provides another arbitration opportunity and a chance to save on court trial costs. On your trial date, you and your witnesses are ready. You already spent all the money it took to prepare for trial. Your case comes up at last on the trial calendar when the court says, "Sorry, we just don't have a courtroom for you." This is the most frustrating moment in the entire legal process, and this may be the single most important reason to suggest arbitration. Why does the court bounce you out when it's given you a trial date? Because there are too many criminal cases, and criminal cases take priority over civil cases. When you get bounced from trial, have your arbitration agreement ready. The other party who spent so much time and energy to finally get this ordeal over is just as frustrated. This is an ideal time for all parties who are prepared and ready to go to submit their matter to arbitration. Often, your arbitration can be heard in a very short time, so all your trial prep will not be in vain. Smart cookie tip: always have an arbitration agreement on hand ready to pull out at a moment's notice. If arbitration isn't selected at this point, trial is postponed for 3 to 6 months, and all the preparation time is wasted. You'll have to gear up all over again for the next trial date, preparing witnesses, rechecking the law as it changes often, and submitting updated trial briefs. Trial continuances are one of the costliest nuisances of the court system that happen repeatedly. Customizing your arbitration agreement. The arbitration providers are packaging arbitrations to be more affordable and accessible by disputing parties. But you don't have to leave the job to them. You don't even need to leave the job to your attorney. You, the person the most interested in your dispute, can package your own arbitration proceeding. You ask, is this really true? I've never heard of this. Yes, it is. You've probably never heard of much of the information in this course. As folks needing to resolve our legal disputes, it's time to get in the driver's seat and set the stage for the best possible outcome to your dispute. With the pace of life as it is now, disputing parties no longer want to be detoured into lengthy, expensive legal proceedings that consume full days. They want to get it done and get on with life. Detouring your dispute to arbitration is a very important step. Arbitration is certainly the best choice when compared with the House of Horrors, but there is another step to take. You have the opportunity to hand-tailor your proceedings with a wide variety of options. This is one of the most important steps you can take after extricating your dispute from the House of Horrors. Don't miss it. Smart cookie tip: if you are creating your own agreement, you can contour the expenses and procedures to fit the needs of your case and your budget. When you chose arbitration, you entered the land of all things possible where you are able to build your proceedings, something you certainly cannot do in the House of Horrors. You can make it streamlined, limit its duration, limit discovery, choose an online, in-person, or document-only platform, require self-representation. You can choose an arbitrator known for expertise in the area of law of your dispute. The choices are endless. Smart cookie tip. If you already have an arbitration agreement, you can supplement it with customized terms as long as all parties agree in writing. This tailoring works both ways. Suppose you receive an arbitration proposal from your opponent. You can then counter-propose any terms you wish, as long as you understand the options. The all-important customization options. Here are some options to consider for your arbitration proceeding. First, engage in automated online blind bidding. Engage in mediation before arbitration. Specify the arbitration provider. The parties will be self-represented at arbitration. The proceedings will be limited in duration. The arbitration proceedings will be, choose. 1. Document only. 2. Entirely online. 3. Entirely in person. 4. A hybrid of 2 and 3 at the arbitrator's option. The winning party will pay the loser's attorney fees and costs. The winning party will pay the arbitrator fees, including administration fees. There will be limited or no discovery. See a sample provision below. Revising the rules of the arbitration provider. And so forth. The Alternative Dispute Resolution chapter further explores these important options. Our ADR forms include these options. These are the ADR agreements we offer in our forms package. Options Addendum to ADR Agreement. Customizing an existing agreement. Mediation. Parties agree to mediate. Arbitration. Parties agree to arbitrate. Mediation arbitration. Parties agree to mediate, and if unsuccessful, to arbitrate. Multi-step ADR. Parties agree to blind bidding, followed by mediation, and if unsuccessful, small claims if within that jurisdiction, if not arbitration. Limiting discovery. As noted previously, it is especially important to consider limiting discovery in your arbitration proceedings. Below are options taken from our forms. Arbitration discovery. The intent of arbitration is to cut costs, particularly discovery costs. 1. No discovery. The parties agree to forego formal discovery procedures such as depositions, interrogatories, document production requests and requests for admission. 2. Limited discovery. The parties agree to limited formal discovery procedures as follows. 2.1. Written discovery. Each party may use any combination of 15 of the following to any other party. Interrogatories with no subparts. Demand for document inspection. Request for admissions. 2.2. Depositions may be taken only with the consent of the arbitrator. 2.3. Other discovery, examinations and inspections may be conducted only with the consent of the arbitrator. Take the time to set the stage for your arbitration instead of blindly walking into the proceedings without considering the many options available. Arbitrator choice. Since arbitration is by written consent, you must follow the terms of your arbitration agreement. The arbitration provider named in your arbitration agreement will be your arbitrator unless you and your opponent agree to another in writing. Typically, the agreement names an arbitration provider. After that, it is up to you and your adversary to review the individual arbitrators and choose the one right for your dispute, or leave it up to the provider's administrator to choose one just right for your dispute. Spend time with the arbitration provider's online arbitrator research tools to identify the best candidate with expertise in your type of dispute. The Arbitration Mechanics chapter delves into this important subject in more detail. Retired judges can be ideal for arbitrations because they have the relevant experience and background. If you're drafting your own arbitration agreement or supplementing an agreement that fails to appoint an arbitration provider, you may want to consider the American Arbitration Association, AAA, or Judicial Arbitration and Mediation Services, JAMS. Smart Cookie Tip: JAMS provides retired judges to preside over proceedings. The extra expense of these arbitrators may not be warranted for your case. Carefully assess this factor. Another newer provider that positions itself as a fast-track online arbitration provider is fairclaims.com, Fast Track Arbitration. Their pricing makes comparisons to the above more traditional arbitration providers. Search the internet for more. Before making a choice, search the rules on their website, talk to them, find out about their Fast Track rules. Rules relating to abbreviated procedures for low to mid-value cases. Document-only proceedings. Rules for online and in-person proceedings. Online arbitrations day has come. Pre-COVID-19, we were pretty much stuck with in-person arbitration, where the whole entire troupe of witnesses, parties, attorneys, experts, even the arbitrator fought traffic to arrive at the same location at the same time to spend an incredibly long day, so they didn't have to do it all over again. We had online platforms, but they really hadn't been perfected, and litigants and arbitrators alike were reticent to engage online. All that changed with the pandemic, where nobody wanted to be in the presence of one another, and if they were masks prevented them from being heard distinctly, which was, of course, essential, but please don't let the germs accompany your words. The demand for better online platforms built to accommodate even complex matters gave way to what we have today, a well-orchestrated real-world online arbitration platform. The online arbitration process is now broken out into shorter segments, allowing the participants more freedom of time, where parties and their teams can appear from anywhere at their convenience. They participate in hearings at pre-planned times of shorter duration and have the luxury of having time to process the information in a more relaxed manner. This allows everyone to avoid the fatigue inevitable in cramming it all into exhausting day-long in-person sessions. This new segmented process also gives the arbitrator an important timeout to process the evidence received and undertake some research of her own, which was not possible in the fatigue-ridden in-person session of yesteryear. It's an important distinction, and yet another reason why arbitration, with its long list of benefits, has blossomed into an online platform that really fits the bill of the contemporary litigant. Smart Cookie Tip: a key element of arbitration is the right for a party to question parties and witnesses. Although written declarations abbreviate the proceedings, sophisticated online technology affords the ability to easily present live testimony remotely, all carefully regulated by the arbitrator who directs the lineup. The entire proceedings can be online or a hybrid process where some of the participants are online and some in person. The arbitrator typically initiates the hybrid process to accommodate differing situations, but parties too can request a hybrid process. Although the rigid courtroom platform gave way to a far more relaxed in-person arbitration arena, it was not until recently, when the online platform came into its own, that disputing parties began to feel comfortable enough to take charge of their own proceedings. With society having become even more technology-focused amidst the pandemic, disputing parties at last found themselves in their element. In cyberspace, they find themselves able to mastermind their legal proceedings as they do with Zoom or Skype or Team. Modern folks at long last find themselves on a platform where they can be in the online catbird seat. Why wouldn't everyone choose arbitration over the courts? Because the disputing parties don't understand it is their choice. They get disempowered and employ the dump truck method, unloading the dispute paraphernalia on an attorney's desk along with their nest egg or a percentage of their potential winnings, and look the other way. Instead, follow these steps. 1. Retire the dump truck. 2. Get an analysis of your dispute with Lawsuit Analyzer. 3. If your case is a go and you have an arbitration agreement with your adversary, supplement your agreement with our options addendum. 4. If you do not have an arbitration agreement with your adversary, prepare one and transmit it to your adversary with the ADR transmittal letter. Smart cookie tip. Why would a potential defendant agree to a forum so their adversary can sue them? Because a lawsuit is just about to be filed where they will be irrevocably dragged into the house of horrors, or they are in a lawsuit with you now and want a better outcome. Can you imagine the freedom of extracting your dispute headed for the house of horrors into a streamlined arbitration proceeding custom tailored by you? It's called Empowered. Time for analysis. Now that you've got your arbitration customized, let's move on to the legalities of your case. Before you file your demand for arbitration, if you haven't already, take these 2 important steps. Step 1. Work your case through Lawsuit Analyzer, which evaluates your dispute and your likelihood of winning, calculates your case value, and identifies the forum and the state it will be heard in. Step 2. Go to our When and Where to File My Lawsuit chapter to determine whether your case meets its filing deadline. If your case looks promising after you do so, move on to the next chapter, Arbitration Mechanics, which steps you through the arbitration hearing itself, and so much more.